We live in a world of constant motion, a world where something is always moving, always going, always changing. One thing affects another. A match may ignite a flame may light a fuse, and a fuse ignite an explosion. Our world consists of one cause after another. Welcome back to Law Dogs. I'm Jeff Henley, your host, and with me as always is Annabelle. Now today's topic, if you haven't guessed it, is causation. Most of us have shot 8-ball and enjoyed sinking balls after a hard crack or sweet bank shot. Whether from skill or luck, each shot conforms to the laws of physics. In torts and other law, we're concerned with the same. For there to be a tort, we have to have causation. We can't just have a tort in the air. The tort, the breach of some duty, has to cause an injury. And in causation, when we're talking about tort law, we're talking about two kinds of causes. First, we're talking about what's called cause and fact. That's the billiard ball cause. That's the one that you're talking about, a physical cause where you see it come forward. It can be like falling dominoes or cars crashing into one another. When we're talking about causation in torts, though, there's another component. It's not just the physical cause and fact component. It's what we call foreseeability. In order for you to have proximate cause, you have to have causation plus something that is foreseeable. When we're talking about foreseeability, we're talking about those things that, we can see in advance. It's that, oh no, I knew that would happen. Or, oh, this doesn't look good. Or, oh, this is gonna go bad. With foreseeability, we're talking about what experience tells us is apt to occur. Fires burn. Wet floors cause falls. Vicious dogs can bite. Foreseeable causes can be as direct as falling dominoes, crashing billiard balls, or just about anything Wile E. Coyote conceived. A crowded club or a rock concert with bad security could lead to people getting trampled. Throw money in a crowded market and people will swarm. Now, foreseeability ties into another element that we've already discussed and that is a part of every negligence claim, and that is reasonable care. Because foreseeability tells us that if you don't do something like this, then it is likely that something bad is going to happen. As a result, if you conduct yourself with the reasonable care that you're supposed to, bad won't happen. In first-year torts, law students hear a case about a man who was running to catch a moving train, and he was carrying fireworks wrapped in some newspapers. Nothing could go wrong, right? Well, the guy runs onto the moving train, and two guards for the Long Island Railroad make matters worse as they awkwardly attempt to help him on board. During a jumble, the guy drops the package and the fireworks somehow explode on the tracks. The explosion is so great that they knock over heavy scales which fall on a poor woman named Helen Palsgraf, who is standing at the other end of the railway platform. The court ruled that the Long Island Railroad could not be liable because its employees could not have foreseen what would have happened next. The court majority concluded that the men could not have foreseen that Helen Palsgraf would have suffered as a result of their failed effort to get the man on board of the train. So when we're talking about proximate cause, we're always talking about what is it that we could see happening as a result of somebody breaching the duty of reasonable care. If you have any questions about this matter or any others, you feel free to email us at lawdogs.com. We'll see you soon. Until then, you stay out of trouble or the Law Dogs will get you.